Okay, we're going to go ahead and get started. So, good afternoon, everybody, and welcome. My name is Taylor, and I am one of DWDC's program coordinators. Today, I am joined by my colleagues Kelsey and Amanda. We would like to begin by acknowledging that the land on which we gather here today is the traditional territory of the Wendat, the Anishinaabe, the Haudenosaunee, Métis, and the Mississaugas of the Credit First Nation. These nations continue to experience ongoing colonization and displacement. Today, Toronto is covered under Treaty Number 13 and the Williams Treaty. Dying with Dignity Canada is also mindful of the broken treaties that occurred across Turtle Island and recognize our responsibilities as treaty people to engage in a continuous process of truth and reconciliation with all peoples across this land. Welcome back to our Myths and Facts series. This session today is all about Track 2 MAID. We know that there are plenty of myths or mixed messages out there, so today we'll really get to the heart of what Track 2 means and what it looks like in practice. Before I welcome today's speakers, I'd like to go over first a few housekeeping items. So everyone on the call today is muted. However, there will be opportunities to submit questions. In order to do so, please type your questions into the question bar that can be found on the Zoom side panel, and we will read it out for you at the end. Please try to keep your questions as clear and concise as possible. While we are going to try to get to as many audience questions as possible, unfortunately, we may not be able to get to everyone. If you have any outstanding questions or questions that are personal in nature, please feel welcome to email us at support@dyingwithdignity.ca, and we will follow up with you. This session today will be recorded. There will also be a post-webinar survey that will pop up on your screen after the webinar and will give you the opportunity to share your feedback with us. And if you'd like to make sure that you're receiving regular updates from DWDC on upcoming webinars, events, our advocacy initiatives, please make sure you're subscribed to any of the social media platforms and channels that you can see here on your screen. We will also be including a link to sign up for the DWDC newsletter in the chat if that's of interest. And now to introduce today's speakers. First up, we have Dr. Chantal Perrot, who is a family physician and psychotherapist in Toronto. An active supporter of choice in healthcare for over 4 decades, Dr. Perrot is frequently called upon to speak about MAID to both professional and general audiences, and is also a member of DWDC's Board of Directors, Clinicians Advisory Council, and the chair for the Board of Directors at MAID House. We also have with us Dr. Eric Thomas, who is a physician, a MAID clinician, and a Canadian Association of MAID Assessors and Providers member who practices out of Stratford, Ontario. He is the current physician lead for the Huron-Perth Palliative Care Outreach Team and has been a MAID assessor and provider since MAID became legal in 2016. After the passage of Bill C-7 in 2021, he also began to accept patients under Track 2 MAID as both the primary and secondary assessor. Thank you so much to our speakers for joining us today. Today's webinar will be a mixed format as our speakers have graciously prepared a short presentation for us, after which we'll pass things over to my colleague Amanda for a follow-up interview. Chantal, Eric, the floor is yours.
Thank you, Taylor, and welcome everybody. Thank you for being here. First, I want to wish a Shana Tova to all of the people on the Zoom call who are celebrating and honoring Rosh Hashanah. And I apologize that we did not recognize the date before the date for the webinar was set, and we hope to do better for that in the future. I'm going to run through a few slides, but we are assuming that most people on the call have some awareness or knowledge of the MAID legislation and how MAID has been operating for the past almost 10 years now. But if there are any questions about that or things that I gloss over or miss, please feel free to ask. Okay, so first set of slides. Again, just to review what medical assistance in dying is, it's the administering by a medical practitioner or nurse practitioner of a substance to a person at their request that causes their death, or in more unusual cases, the prescribing or providing by a medical practitioner or nurse practitioner of a substance to a person at their request so that they may self-administer the substance and in doing so cause their own death. Most of the MAID procedures in Canada are done using option A, which is an intravenous medication administration. Next slide, please. Just go through a brief history of of MAID in Canada. In 1993, Sue Rodriguez challenged the criminal code, I guess, and legislation at that time, wanting to be able to end her life. She was a young woman living with ALS. In a 5-4 decision, the Supreme Court of Canada at that time dismissed her appeal, which was difficult at that time. And she ended up taking her own life or ending her own life earlier than might otherwise been possible. And not much happened between 1993 and 2015. I think a few bills were introduced. None of them made it very far. But then in 2015, we had the case with Gloria Taylor and Kay Carter. Gloria Taylor had ALS and Kay Carter had spinal stenosis, and the Supreme Court agreed unanimously at that time that the Section 7 rights of the individual were being infringed and declared Section 241 of the Criminal Code to be invalid, which allowed for MAID legislation. The federal government was given a certain amount of time to draft legislation. They took longer, got extensions, but ultimately in 2016, Bill C-14 was passed, granting an exemption to the criminal code to allow for legal medical assistance in dying for those who met the eligibility criteria. And I think it is important to note that it's an exemption from the criminal code and that we need that in order to be able to provide MAID. In 2019, two individuals in Quebec, Jean Truchon and Nicole Gladu. Jean Truchon had cerebral palsy and Nicole Gladu had post-polio syndrome, and they challenged the MAID law in the Quebec courts, and the Superior Court of Quebec found that it was unconstitutional to limit their access to MAID, to limit access to MAID to people only nearing the end of life. The government of Canada did not appeal that decision, and that resulted in Bill C-7 in 2021, which removed the reasonably foreseeable death requirement of the original legislation and allowed those with grievous and irremediable medical conditions, but who were not necessarily on a direct trajectory towards death at that time, to seek MAID. So as of 2021, we essentially had two tracks. Track one for those whose deaths were reasonably foreseeable or reasonably predictable, and track two for those whose deaths were not. Next slide, please. These are the eligibility criteria as of March 2021. They were essentially unchanged except for the removal of the safeguard for reasonably foreseeable natural death. So somebody still had to be eligible for health services funded by a government in Canada. They didn't actually have to have the health service yet or health access yet, but they had to be eligible for it. They had to have a grievous and irremediable medical condition. They had to be at least 18 years old and capable of making decisions with respect to their health. They have to have made a voluntary request for medical assistance in dying that was not made as a result of any external pressure or coercion. And they had to give informed consent to receive MAID. Next slide, please. Again, the subcriteria for grievous and irremediable medical condition also had to be met, had to be a serious and incurable illness, disease, or disability. The person had to be in an advanced state of irreversible decline in capability, and the illness, disease, or disability, or the state of decline must cause them enduring physical or psychological suffering that is intolerable to them and cannot be relieved under conditions that they consider acceptable. And this subcriterion is a very subjective one. It's up to the patient to tell us whether or not their suffering is intolerable. It's not up to us or anybody else to determine that. Next slide, please. There are a whole series of safeguards. These are the safeguards that are for both tracks. I'm not going to go through all of them, and then those existed for the most part before Bill C-7 came in and have been maintained afterwards. Next slide, please. And we'll go on to the next slide, please. These are the additional safeguards that were put in place for track 2, non-reasonably foreseeable natural death. So if neither the medical assessor has expertise in the condition that is causing the person's suffering, one of them must consult with a medical practitioner or nurse practitioner who has that expertise, and they must share the results of that consultation with the other practitioner. So it's not that the patient has to see another clinician necessarily, but the MAID assessor must consult with somebody who has that expertise to ask questions, determine if there's anything else they should know or do or suggest to the patient before they can be found eligible or before they can receive MAID. Next one is that the person seeking MAID must be informed of the means available to relieve their suffering, including, where appropriate, counseling services, mental health and disability support services, community services, and palliative care, and they must be offered consultations with relevant professionals who provide those services or that care. And one of the reasons that we might seek or want to seek somebody with expertise, even if it's not mandated like under Track 2, is to find out, are there any other treatments that we may not be aware of as assessors and providers that could be offered to our patients that might help them and even make them change their mind and not want to seek MAID or not want to seek MAID at that point. But all patients who are on Track 2 must have access to that information. And another safeguard is that both assessors must ensure that they have discussed with the person the reasonable and available means to relieve their suffering, and both assessors must agree with the person that the person has given serious consideration to those means. So somebody can't just hear a list of things that they could have and automatically dismiss it. They have to actually understand what each of those things would be and what it might be like for them to make avail themselves of them. And finally, there must be at least 90 clear days between the day on which the first assessment begins and the day on which medical assistance in dying is provided. Now, a lot of times people refer to this as a reflection period, and it's not a reflection period. It's an assessment period. And that's to make sure that there's plenty of time for MAID assessors and providers to get the information they need to do a proper assessment, to engage with the patient and any of the clinicians with expertise that they may need to consult. Some of the Track 2 cases actually take much less than those 92 clear days, but we still have to wait for the 90 clear days to elapse. And others cases, it takes longer than the 90 clear days, in which case we do take longer. We don't just provide after 90 clear days. Any more slides?
Nope, that's the end of the.
Just one or two other things. As we know, the main reason for applying for MAID can't be because of mental health illness. So you can't apply with mental health being the primary diagnosis. And just to expand a little bit upon consulting with consultants, experts, this sort of thing. We don't ask them if the person should or shouldn't have MAID, of course. It's more a case of, you know, assuring that for this particular condition, that any and everything has been considered, offered at the same time. That doesn't obligate the individual to have to go through extra treatments or evaluations if they don't wish to do so.
Okay. Chantal, Eric, thank you so much for that presentation. As Taylor had mentioned in the beginning, we're now going to move on to a brief interview that covers a bit more about Track 2. So to get started, let's talk a little bit about before Bill C-7 in 2021. So before it was passed in 2021, clinicians like yourselves could only provide MAID to somebody that had a reasonably foreseeable natural death. And just as a refresher here for the audience, I'm wondering if one or both of you could provide a bit more information in layman's terms about what a reasonably foreseeable death is defined as, what that actually looks like, what that means. And maybe we'll start with Chantal.
Okay, so as a starting point for me, I go back to the original legislation and the federal government backgrounder documents that were produced at the time in 2016. And then there were a couple of subsequent lawsuits, particularly the AB lawsuit in Ontario in 2017. For me, in doing assessments, death is reasonably foreseeable if the person is on a trajectory towards death. If their predicted lifespan is less than 10 to 12 years, which is consistent with the Carter decision. And then if the individual has more nuanced decision, then it's an individual and more nuanced decision based on the individual's circumstances. So that's the kind of the background that I use. And for basically, when I look at a situation, if a patient would have been approved under Bill C-14, they would be, for me, on Track 1. If they would not have been approved as a reasonably foreseeable natural death before 2021, then they would be on Track 2.
Thank you.
Yeah.
Eric, anything to share there?
Yeah, I agree with that. Just to illustrate, so that's why somebody with advanced Parkinson's disease would typically be, Track 1, natural death reasonably foreseeable. we have no idea what the time of death would be. And yes, it could go on for a couple of years, but the trajectory is always there. And we know, all being equal, that disease process will be what causes their death. So there's no set time. In practice, I tend not to go 10 years. My own personal practice, the question I ask myself, what's the reasonable odds that this person would still be alive within 1 year, within 2 years? But of course, Chantal's absolutely right in saying, that's what the legislation says, and we are very bound to the legislation.
Thank you so much. Moving on to the next question before we talk about the MAID framework today, I'm curious about the experience that both of you had as clinicians before Bill C-7 was passed and what it was like to assess and provide MAID under the original criteria and safeguards. And maybe Eric, we'll start with you first.
Well, Bill C-7 did change things, not so much, I mean, every patient we saw, we knew that natural death was reasonably foreseeable. And if there are patients with, chronic pain or whatever whatever it was that, they wanted to discuss MAID for, if their death was not reasonably foreseeable, they wouldn't be seen. But one major thing is, not only did Bill C-7 allow for not reasonably foreseeable death cases to be seen, but it also allowed for waiver of final consent. So that was quite a big one as well. Prior to C-7, there are a lot of people who lost eligibility for MAID because they lost capacity, because you have to give a final consent prior to having a MAID provision done. With the allowance for there being an agreement, waiver of final consent, which allows individuals to have a one-to-one understanding contract with their potential provider, that if capacity is lost, then using proper discretion, the provider could then do the provision. The other important thing is, before that, there are a lot of people, well, some people, and it was illustrated in news stories, some people who elected to have their MAID procedure done up to a couple of months before they wanted to, because of fear of losing capacity. And that took away the whole point of MAID entirely. The whole point is to have the security, the relief that MAID will be an option to you. And so, rather than it becoming a fear for some people, so that was a big change as well.
Yeah, absolutely. As well as the 10-day reflection period that was also required and later removed with Bill C-7. Chantal, I'm
Mhm.
curious if there are any other insights you might have about that experience before Bill C-7 and what it was like to assess and provide.
I would say the assessments under C-14 still required really thorough and nuanced assessments and considered interpretation of the legislation, which was legal, not clinical documents. So that was difficult, especially in the early years to do that. And we've grown and evolved over the years. MAID assessors and providers became a lot more experienced. We communicated a lot with each other, learned from each other, learned from the case law that came afterwards. And so we've certainly benefited from all of that. But I would say, in terms of doing my assessments, really not much changed, because I wanted to be as thorough and compassionate as possible in doing it. There were, again, the added criteria or safeguards that had to be met under the track 2 under C-7, but you want to do your due diligence and do the best for the patients. And not everybody who applied for MAID, and even not all who are eligible, actually have MAID, because sometimes they are so relieved that they have it in their kind of back pocket that they end up dying naturally. And that's a win. I mean, that's good for the patients, it's good for their families, and it's good for everybody.
Yeah, well said. All right, for next question, let's talk a little bit now about the shift from Bill C-14 to Bill C-7. And just as we had talked about the definition of a reasonably foreseeable natural death, I'm wondering if we can get a bit of an explanation about what a non-reasonably foreseeable natural death is, or what some of the conditions and underlying conditions might be for somebody who qualifies for MAID but doesn't have a reasonably foreseeable natural death, and how that sort of works. And maybe we'll start with Eric this time.
Okay. I mean, obviously, if you're interviewing somebody who's of certain age, you could say, well, of course, death is naturally foreseeable because they're already 80 or 90 years old. But for MAID, age is not the criterion that's used to determine foreseeable death. So for the non-foreseeable, whatever the condition is, we'll say chronic pain of whatever sort. Um, it's not known to be a fatal condition. So chronic pain all by itself is not known specifically to cause death, even though there's suffering and there's harm. Um, it's not fatal per se. Sometimes, depending on the situation, chronic pain, chronic disability can then, especially in the elderly, lend to extreme frailty. And sometimes extreme frailty can transition over to track one, depending on, their frailty scale. That helps.
Yeah. Thank you so much. Chantal, same question for you. How, in your words, would you define somebody who has a non-reasonably foreseeable natural death? And what does that look like?
Well, as I mentioned before, for me, anyone who would not have been eligible under C14 would automatically become track two in my mind. And that generally means younger people and those with less clearly defined diagnoses. As Eric mentioned, chronic pain. We see a lot of people with chronic pain. I don't mean chronic pain just for a few months, people living with chronic pain for years. Sometimes it's difficult to diagnose or find an underlying diagnosis for it, but the pain is clearly there. And then there are conditions like fibromyalgia, chronic fatigue syndrome, which have difficult etiologies. We don't necessarily understand all of what triggers them, what causes them, what the underlying pathophysiology is, but we do understand their trajectory and how they go. So again, somebody early in a disease process with those things wouldn't necessarily be eligible, but someone who has lived with it and has tried treatments, has done things for a long period of time and has reached the conclusion that they don't want to live with it anymore could possibly be eligible. Then there are various chronic gastrointestinal disorders like severe irritable bowel syndrome, which may sound like it's just a simple thing, but that can cause severe pain and lead to incredible weight loss and cachexia and fragility and frailty, even in fairly young people. So it's, again, there are more rare conditions as well that would fall under that. But each of these people has to be assessed, and somebody with the exact same condition might be eligible for MAID. Somebody else with that condition might not. It really depends on the details and their particular circumstances.
Absolutely. Case by case, right?
Yep.
Okay, let's move on now. And Chantal, we'll start with you. Let's talk about when you assess an individual that's requesting MAID. I'm curious about what tools or considerations you use, or if you don't use anything different, to determine whether a patient, sitting in front of you would fall under track one versus falling under track two.
Again, I come back to if they were eligible under C14, they're track one. If they wouldn't have been, then they would be track two. And then again, there are more nuances that go along with that, but that's the starting point for me. And again, eligibility is determined before track. So somebody has to be eligible, found eligible, meet all of the eligibility criteria in the legislation, and then we apply the safeguards to determine which track they would be on.
Wonderful.
Again, I also mentioned them, they're patients that I would put on track one, but if I think that there's something that could be offered to them that could help ameliorate their condition, or if I think consultation with somebody with expertise who can give me some advice to be helpful to the patient, then I will do that. And sometimes it will take longer to do that track one assessment because I want to treat all the patients with the same lens.
Yeah, absolutely. Do you find it's the same for you as well, Eric, or different?
Well, it'd be very, very similar. I must say we don't necessarily use tools. Um, it's largely the dialogue that we have with the with our patients. Um, Obviously, the more complex the patient, the longer that the dialogue is going to be. The other key thing I find for particularly track two, sometimes track one, is that you hear the testimony of the applicant, you hear their suffering, but at the same time, you have to have proper corroboration of just of just what that suffering means or where it comes from. If they have chronic pain coming from severe spinal stenosis, well, you can look at their MRI scans and you can have the objective data from that. You can have the the opinions from the surgeons, pain specialists, all that have seen and treated these people. But then you transition over to other conditions like take fibromyalgia, for example, where it's really hard to get the corroboration because just what are the objective features of that disease. So that much tougher. So you're not going to have tests that demonstrate it. So all the more onus there is on the assessor to get countless opinions from the all the specialists, not just the specialists, but all the support people that these individuals have seen over the years. So there has to be the corroboration of what the suffering is, and relative to what has happened in the past. And furthermore, to what Chantal said, it's unusual for us to see any of these people early in their illness process. Um, it really usually goes on for years and years. If someone is relatively new diagnosis of severe pain, well, it's pretty unlikely that we would even, to take them on. Might have a conversation, says, but no, you really have to do A, B, C, and all the way through X, Y, Z, perhaps, before we need a reasonable discussion for MAID could even happen.
Thank
Yeah, I
you.
think that's important to recognize that somebody has to have seen some people with expertise over the time they've had a condition so that they can understand what the options are. And we have to see that they've tried various things that have not worked for them, and to reach the point where there's not very little that the medical care could offer them. And that is true for a number of people.
And it's not unusual that we'll encounter people that do have overlap with mental health conditions, and you do get this category of people who have what they call functional illnesses. Where it's felt by the various specialists that they've seen that their suffering, their physical suffering, is more generated by their underlying, mental health illness or that sort of thing. Again, that just adds a whole new layer of complexity to, to see if you can, help these individuals.
Sounds like it represents a lot of determination, a lot of work, a lot of review, and a lot of data from a lot of different sources to make that right determination, not only if they're eligible, but what track as well, and therefore what safeguards. So thank you both for showing us a bit of a window into that process. We're now going to move on to discuss clinicians at MAID at large. We've heard before that it can be more difficult for individuals without a reasonably foreseeable natural death to find qualified clinicians that are willing to assess them and to hold their hand through the process. And so I'm curious, maybe to start first with you, Eric, why do you think there are less or fewer clinicians that are willing to assess and provide for Track 2 MAID, even if they already assess and provide MAID for individuals under Track 1? Why then, when the law changed in 2021, did you, for example, choose to assess but patients under both tracks?
I'm not sure how well I thought it through. Um, I was asked to see these people, and I said, okay. And over time, I came to realize just how difficult, how complicated, some of these situations would be. And ultimately, by the time provision happens, you have to give your story to the provincial coroner. And so your story has to be not okay, not good. Your story has to be pretty excellent, with the story covering everything that needs to cover. So yes, there is extra time because you're having multiple assessments, whether they're in person or whether they're done over the phone or whether they're done virtually. There's many more assessments, conversations, follow-up discussions, what have you. You're also talking to the other assessor, and you're going to be talking to a whole lot of other support people. So more time, more expertise. The other thing is there are areas that are already underrepresented with MAID providers, and they simply do not have the time to take on that sort of caseload. Hypothetically, say if this caseload is largely managed by say nurse practitioners who are funded in a totally different way and underfunded, by the way. We probably should get that one in. All this extra work and time, they don't even get paid for it. So so there's availability of assessors, and there are some areas that are very underrepresented for assessors. And there are some other assessors who are worried about the backlash of external forces, such as, will they, there is some relative fear about, is their report going to be up to snuff for the coroner's office? Will they get all sorts of negative repercussions from friends and families of this individual? Will their cases end up in news stories from the detractors of MAID? There's lots of other potential thoughts and worries that may creep into these for these individuals.
Wow. It sounds like there are a lot of external factors that really impact whether a clinician chooses to opt in or opt out. Chantal, do you see those similar reasons in your experience as well? And again, I'm curious as well why you chose to assess patients that could fall under either track.
Yeah, I agree 100% with what Eric said. And I would say choice and autonomy really underpin my approach to MAID. And I think anybody who applies for MAID or who wants to consider MAID has, I would like to say, has a right to an assessment. I mean, we don't always have access to assessors and providers, which we know, are in relatively short supply. But if anybody was referred to me or got my name and number from their clinicians and wanted to have an assessment, I would speak to them and do an assessment. Doesn't mean everybody would be eligible, but I think that they deserved an assessment. And I always found the assessments, even for people who were not eligible, whether under track 1 or track 2, it was an educational experience for them, because then they could learn more about MAID and the MAID process and the nuances and understand the legislation better. I think people who reach the point in their lives where they're suffering enough that they jump through all the hoops that you have to jump through to try to get to a MAID assessor, and they're that determined to end their lives because of their suffering, deserves the benefit of having a MAID assessment. And for the track 2 cases, they do take longer, and they often have a longer timeline attached. And sometimes clinicians have a hard time managing that in the context of their practices. And because we need to liaise with clinicians with expertise, and as Eric mentioned before, we're not asking the clinician with expertise whether or not they agree that the person is eligible for MAID. It has nothing to do with that. It's to learn about their condition. But that can take a fair bit of time with phone calls back and forth and back and forth. With people on track 2, there's often an extensive body of medical record, and that takes a fair amount of time to wade through, to get access to, for one thing, to pull all together, and then to read through and consider and determine the kinds of questions and things that we would need to ask specifically of them in their MAID assessments. And also, as Eric pointed out, a number of patients on track 2 in particular do have confounding mental disorders as well. And so sometimes they're going to give you questions of capacity and how much is their mental disorder influencing their physical condition, how much is it influencing their request for MAID. So we really have to spend a lot more time teasing out capacity, and in some cases seeking an external capacity, formal capacity assessment. And then, as Eric pointed out, all of the negative and erroneous information that's in the media is daunting to all of us, I think, and is a major deterrent for a lot of people. None of us want to see our cases misrepresented in the media, as I certainly have, and I'm sure Eric has as well.
Yeah,
And
absolutely.
sometimes they'll publish our names.
Mhm.
Very, very, very distressing.
Yeah. Yeah, well, thank you both for sharing a bit more about that. Before we move on, I have 2 points that I'd like to quickly touch on. The both of you had mentioned individuals sometimes having concurrent physical and mental conditions. And maybe just to clarify for the audience, I'd like to ask whether it's possible or not for somebody who has a physical condition to also qualify under MAID by having a physical and mental condition, or if individuals present with a mental condition cannot access MAID.
Oh, no, absolutely. As long as there is a physical condition that is driving their request for MAID, people with mental disorders, certainly if they're, as long as they have capacity, they can be eligible and can receive MAID. And, with a lot of the physical conditions, I mean, there is a certain amount of anxiety or depression or whatever that goes along with those conditions. And you can't be in a lot of suffering and not have some kind of emotional response to it as well. So part of our job as assessors is to do capacity assessments basically on every person we encounter in all of our medical practices, but certainly in the context of doing the MAID assessments, to make sure, again, that their request is not driven by what could be an underlying treatable psychological condition.
Yeah, the answer is yes. And there are a lot of people applying who do have various spectrum of mental health, but as long as the it's determined in whatever way needed that the request is not being driven by mental health, then that's absolutely fine. It's very common for there to be something of mental health history, particularly with track two applications. There are some track two conditions that lend to mental health problems. If you have chronic traumatic brain encephalopathy, it does cause mood changes. It does cause it does cause mental health issues. The condition itself can sometimes do it.
Absolutely. Thank you both. All right, so before we move on, let's discuss one aspect of Track 2 safeguards that I wanted to hone in on from your presentation, Chantel. One of the safeguards for Track 2 requires that the requester or applicant has been informed of and has seriously considered treatment alternatives that could alleviate their suffering, including palliative care. And I'm curious for the both of you as clinicians, how specifically do you verify that that applicant has properly and reasonably considered those alternatives? What does that look like?
I would say it looks pretty extensive. Um, for track two, it's rare that palliative care is a topic. Palliative care doesn't necessarily mean end of life care, but not many people actually need palliative care support. When they're track two, they often need chronic complex care support, which certainly does have similarities. Um, but in terms of finding out, knowing what's happened in the past, it is comprehensive. Um, we need to know who they've seen along the years, and we actually even want to find the documentation for that. So I'd say it's pretty extensive. And if they haven't gone through those various steps of assessments and reasonable treatments, then we would recommend to the patient as probably to the family doctor as well. Hopefully they have one that, well, this really needs to be done. This really needs to be done first. I think we're not quite in the right order of sequence here yet.
And Chantal, again, same question for you. How are you as a clinician, verifying that that applicant has seriously considered previous and perhaps alternative treatments?
Well, in order for me to assure that they've seriously considered them, I have to know about them. So sometimes I have to educate myself even more to find out what those treatments might be for the individual. And then, I have extensive conversations with patients. I mean, for track 1 for sure, but especially for track 2, those assessments take place over a fairly long period of time, often involve lots of phone conversations, sometimes multiple video links or in-person meetings, phone calls, emails back and forth. So I need to have a good understanding of them, why they're applying for MAID, what their conditions are, how the conditions are affecting them. And then I need to know what they've done and what they're willing to do. And I have to be clear that I've presented to them, gone through the things that could be offered to them or that may have already been offered to them by their treating clinicians, and make sure that they've considered them and thought about them. And so if they talk to me about them and they can give me cogent reasons why they've tried them and they haven't worked, or they've decided that those treatments are not for them and they're not willing to go through any additional pain or suffering that side effects or whatever may cause to them, that can be enough. But I need to know that they have actually thought about each of those things and given them good consideration. And the way I do it, again, is through those extensive and often multiple conversations.
All right. So our previous questions have been covering facts. Now it's time to talk about the myths related to track 2 MAID. So for my next question, and Chantal, we'll start with you this time, in your experience, what do you find is the most concerning myth or misconception that you've heard about track 2 MAID? And this could be with your own patients or colleagues or fellow healthcare practitioners in the space.
Well, the thing that I hear about the most actually comes from the media, and sometimes in the media talking about my patients when they get the facts wrong, have inadequate information, which I cannot respond to. But the thing that gets me the most is people saying that people can receive MAID based on inadequate housing or financial circumstances. And that's just not true. And do we assess for their housing circumstances and their financial circumstances? Absolutely, because I want to make sure that those are not the major contributing factors. Do they affect somebody's illness experience? Absolutely. Do they affect their quality of life? Absolutely. So are they possibly contributing factors? Yes, I have to say that they could be. But are they the major, the only reason? Absolutely not. And that is one that is frequently brought out by the anti-MAID people, both clinician or both medical practitioners as well as others. Frequently in the media, the same stories get rehashed over and over and over again. We see them in our local media, we see them in the national media, we see them in the international media. And that's extremely frustrating because it gives a very false impression of how MAID is actually done here.
Thank you. Eric, same question for you. In your personal experience, what's the most concerning myth or misconception that you've heard about track 2 MAID?
In a way, I've been lucky in that working in a smaller area, like not a metropolitan area, I don't have it quite as much. But with Chantal's point about the detractors, they really focus very hard on oh, MAID is killing these unfortunate people, adopting a very paternalistic approach, almost making out these poor victims, when in fact these individuals do have autonomy. They do know what their suffering is, and they do know their life experience. Now, in terms of numbers, it is interesting to know that those who'd be considered socially disadvantaged, they apply for MAID considerably percentage-wise less than more affluent people. So the poorer you are, the actually less likely you are to apply for MAID, according to the to the numbers, which are pretty accurate.
Yeah, those are the statistics, but I'll say living and working in Toronto, I see a broad range of socioeconomic backgrounds. And even the most socially or economically disadvantaged people, they were clear and firm about their decision to seek MAID. And I always ask people about their financial circumstances. And after I go through a whole bunch of questions, they say, why are you asking me this? And that's basically, I said, I want to try to understand, are your financial circumstances contributing in any way to your request for MAID? And most often the answer is very quickly, no, not at all. Even if I had $1 million or $100 million, that would not change what I'm going through. That would not change my mind. So that's very clear to me.
Yeah. But again, the detractors, they really like to push at that. I guess perhaps you see it as low-hanging fruit or something like that. I don't know. And again, they portray them as in a very paternalistic type of way, which is pretty annoying because these people know who they are. They have their rights. They have their brains. So as Chantal was saying.
Yeah. To talk a bit more about a few concerning myths we've heard previously, I'd like to touch on a couple. So, to start with, one concerning idea is that there is a trend that clinicians encourage patients, including patients that haven't inquired about MAID, to pursue MAID under Track 2 instead of offering adequate health care or social supports, including palliative care. And I'm wondering if either of you would be willing to bust this myth and talk about the resources that are offered to applicants, and how the discussion of MAID is typically brought up for the two of you as clinicians with your patients. And we'll start with you, Eric, this time.
Okay. And I'll have it not just for track two, but for but for every single assessment I've ever done. In the approximately 1,600 encounters I've had with MAID, I can say that I've never offered MAID to anybody. It doesn't happen. I always see people because I've been asked to see them, and I have never concluded to a patient, well, MAID's the right thing for you. That's never happened either. It's always framed in, these are your options. Now, in terms of track two, um, no surprise, the majority of people, have already been in contact with various social agencies. They're often on disability, so most of them are fairly fluent with housing and social assistance and whatever there is. If they're not, and I haven't encountered it, if they're not, they'd quickly be referred to those services, and would probably, in a sense, put their application on hold. But for me, that's hypothetical because I haven't come across that.
Yeah. Chantal, same question for you.
Pretty much the same as Eric, but in some ways it's a difficult question to respond to, let alone refute, because I'm not in the consulting room when other clinicians are doing assessments for whatever reason. And I can well believe that a patient whose doctor informs them of the existence of MAID as a treatment option, whether in general or in their specific circumstances, could be interpreting that as encouraging them to pursue it, when that may not be the case at all, and certainly may not be the intention of the clinician. They're often very emotionally charged situations where you're providing end-of-life care or care to somebody in difficult circumstances. And so what they hear and how they hear it may be very different than what you intend. And we don't have a lot of control over that. And we can try to be careful in how we express anything related to MAID, and perhaps couch some of the information in qualifying terms, like saying outwardly, I'm not suggesting that you do this or recommending it to you, but I want you to know that about this is something that exists as one of your treatment options. But still, we can't control how somebody hears that. And whether those things actually happen and things that the way they were reported in the media, I can't know. As with Eric, I'm a referred to physician. I don't go out and solicit patients. They have to get referred to me. And I don't think most MAID clinicians actively do solicit patients because we have more than enough. And on the contrary, I think patients have to do a lot of work to actually get in touch with us and to get connected with the MAID assessor and provider. But the media stokes the flames of that misinformation by repeating the person's belief that they were encouraged to pursue MAID with that being fact. And again, I have a lot of sympathy and empathy for people who think they were being forced or coerced or pressured into receiving MAID. But I also have sympathy for the people in the medical system. I'm not sure that that was actually accurate. And so you have to try to work both sides and support both sides.
Getting
Thank
back to
you.
it, so I also do palliative care. When I do a palliative care consultation, MAID is usually not brought up at all. I'll stick to the palliative care concern. If the individual or even their family raises the topic, I'll sort of go from there. There may have been one or two episodes where I asked the question because they're asking for all their options. I would ask, are you aware in Canada there's a law that allows for assisted death, and that's yes or no, and you know it may or may not expand from there, but it's never offered. There was a situation where some bureaucrat at the Veterans Affair was telling veterans that they should apply for MAID, but that actually happened. But that was misguided, and that was dealt with, but that really hit the news. It certainly wasn't anything to do with physicians.
Yeah. Okay. The second myth that I'd like for both of you to bust is the idea that Track 2 MAID is disproportionately accessed by vulnerable persons. So, underneath that umbrella, that can include individuals who identify as women, persons with disabilities, people living in poverty, and persons of color. And the concern there is that these groups disproportionately access Track 2 MAID as the alternative to accessing adequate health care or social supports. Now, both of you had mentioned and touched on this a bit in previous answers, but I'm wondering if you can provide a more fulsome answer to bust this myth about Track 2 MAID and vulnerable populations.
It's just not a thing. I mean, I would hesitate to have to put women into a vulnerable group in general. I mean, about it's pretty close to 50-50 people applying for MAID. When you get into the older populations, it is proportionally a little bit higher with women, but that has everything to do with women already living longer than men. That fits in with the numbers. For me, it just isn't. It's just not a thing with disadvantaged and all that. So it's just not a thing.
I think it's also making a grave assumption that women are vulnerable, that persons with disabilities are necessarily vulnerable, that people living in poverty are necessarily vulnerable in the ways that the media or the people who are against MAID try to suggest. I think the statistics do show that there are more women who receive MAID under Track 2 than under Track 1, but I think that's because the conditions that they have are more common in women than in men, and so that's going to make a difference. In terms of more people with disabilities applying for MAID, I think that's probably true. And for a lot of people on Track 1, I mean, one of the questions we have to ask everybody is, do you consider yourself disabled? And sometimes it's shocking to me when people say no when they're using wheelchairs or whatever, but that's not the vision they see of themselves. And then they say, oh yeah, well, I guess if I'm using a wheelchair and I can't do this by myself, then I guess I am disabled. And then others who clearly see themselves as disabled and accept that they're disabled, but it's their underlying condition that's leading them to choose MAID. It's not the disability itself or the fact of the disability, though the suffering from that can certainly contribute to it. But it's going to be unlikely to see a healthy person receive MAID.
Also goes back to the previous point made that the detractors, they really seem to want to have a very paternalistic approach. We need to guide these people. We need to be their shepherds. But that's just not the case. And I agree with Chantal. I've talked to people who anybody would consider to be disabled, and if you ask them, I'm not disabled. You know, um, most people we see with discussing MAID, they have good levels of pride, and they always, and as well as good levels of autonomy.
Yeah, it sounds like it's really about balancing the data that we see with the news that we hear at times. And that leads me to sort of my next question that sometimes we hear concerning stories in the media or, anecdotes shared around the kitchen table about individual patients and their circumstances under which they access MAID, and how sometimes that single case is presented as proof of a broader trend or a slippery slope. I'm curious from the both of you what you think about how the public should weigh these individual stories against the larger long-term research projects, and how to sort of rationalize what you might hear and see versus, what the data tells us, and how to sort of suss out the truth from stories that we read or hear about. And maybe Chantel, we'll start with you first.
Well, I would say ideally the public would question and seek evidence for what they hear or read in the media. None of the case stories presented in the media have or present all the facts, all the details that the clinicians examine in the course of doing their assessments. The media use bits, the what do they call it, clickbait, bits pulled out of context to serve their own ends more than to educate or inform. So I think there's a lot of sensationalism that goes on, things that draw us to read particular articles, and I think we do need to be inherently skeptical.
Inherently skeptical. Okay. Eric, is it the same for you as well? What would you advise somebody who hears these concerning stories in the media and weighs that against the data or research that they can find?
We'd really have to discuss it more in not so much based on data, but say that these are people who have their agendas. They're distorting what the facts are. They're just trying to you know take down the legitimacy of made legislation by presenting their distortions. Now, I think we're all very aware of the powers of the media. You can argue that there are entire nations these days that are influenced by biased media. So in many ways, there's not a whole lot of not much defense against it. But more and more, you're seeing you know well, fake news, I guess. So you're just seeing more and more sensationalist stories in the news, and you're not even sure what the sources are a lot of the time. It's difficult. It's difficult, but we just have to respond in an individual way as best as we can if it comes up.
Thank you both. For our final question, I'd like to ask you both, what would you say to those who argue that it's better to prohibit Track 2 MAID given the current inadequacies in our healthcare infrastructure, or some who suggest to pause Track 2 MAID until better systems of healthcare are provided for? Maybe Eric, we'll start with you this time.
Well, if that's the premise, then it it's a false premise, but that would basically suspend Track 2 made forever, because we do work within an imperfect system. It never has been perfect. And in other perspectives, there's really only you know three countries in the world that have similar legislation. There's us, there's Holland, and there's Belgium. Um, so Track 2 MAID, even though it only accounts for something like 2.2% of MAID provisions, it's a valuable service, and any time I've administered it to my patient, It's been the right thing for them, and nearly always, corroborated, supported by their families. It's you know, so yeah, Chantal.
Yeah, my response to that is that individuals suffering should not be held hostage to an imperfect world or an inadequate healthcare system or social infrastructure. People are making decisions based on their individual circumstances and lived experience and should be able to make the decision that they believe is best for themselves, not what a politician or an anti-MAID activist thinks they should do. And is it sad? It's difficult. And there are times when I provide MAID or do assessments for MAID, and it's very, very difficult. And I realize that there's nothing that could be reasonably offered to the person to ameliorate their circumstances, and forcing them to suffer because there could be a treatment or a cure somewhere down the line that could be of help to them, or because they maybe they could get more services on a daily basis to help them at home that might prolong their lives, but not necessarily make them feel any better. I just think it's wrong to do that.
Thank you both so much. That concludes our interview portion. We're now going to move on to the audience Q&A. Thank you so much to our audience members who've been listening in, submitted their questions through registration, as well as throughout the session today. We're going to go ahead and get started with a few rapid fire questions. And in the interest of time to get through as many, we'll go with one speaker for the most part, but if there's something you really feel needs to be added, feel free to jump in. So let's start with Chantal for this question. This audience member asks, would being diagnosed with dementia qualify somebody under track 1 or track 2? And what goes into that decision making specifically when it comes to dementia and assigning a track?
In general, I think most clinicians would put most people with a diagnosis of dementia on track 1 because they are on a trajectory towards death, and the average lifespan for somebody with dementia is 7 to 8 years, something like that, and that's well within the window for reasonably foreseeable natural death. And again, each case is going to be different, so it depends on the circumstances of the case, but I think that's in general. And maybe this is a time to, I think this is a national webinar that we're doing. There's a lot of variability across the country and even within provinces in how clinicians interpret these things. So there may be some clinicians that would see somebody with an early or even moderate dementia and put them on track 2, whereas another clinician assessing them might put them on track 1.
As you said before, case by case.
Case by case, yeah.
Yeah.
And,
All right.
we are allowed to disagree with each other. Not all clinicians are cookie cutter, and we do assessments based on our clinical experience and our expertise, and we come to clinical conclusions that we have to document in all of our notes and consult letters and that kind of thing. So we have to be clear about why we're making the decision we're making, and we have to be able to justify it.
Thanks to that audience member for the question. Eric, you're up. This audience member asks, if somebody has multiple overlapping conditions, and let's assume physical conditions for the sake of the argument, would eligibility for track 2 be more likely?
Well, it all comes down to trajectory towards death. You can have multiple illnesses, and if these multiple illnesses ultimately culminate in frailty, advanced frailty, then more often than not, that's track 1, because frailty very much has a trajectory towards death. So in general, be track 1, unless all these things added up. We just couldn't see reasonably foreseeable death be track 2 then, but quite often it'd be a track 1, with every case being individual.
Yes. So it sounds like in this case, it doesn't really matter how many diagnoses an individual has. That doesn't really point towards track 1 or track 2, but it's rather about how those diagnoses impact that person and again, the trajectory of those conditions and whether it points to natural death or not. Okay, thanks, audience member, for that question. Next up, Chantal, we'll point to you for this question. They're talking about Robert Munch, very famous Canadian storyteller, who's been in the news recently about his decision to pursue a medically assisted death. Now, of course, we can't speak on the specifics of his circumstances. Not all has been shared. But this audience member is curious about providing perhaps a general overview of MAID and dementia and how those two intersect and, having a dementia type disorder and sort of what are the considerations that somebody with that might have to consider for MAID.
Well, anybody diagnosed with dementia can certainly make an application for MAID, and there will be some people with a diagnosis of dementia that would want to receive MAID early in the diagnosis because they don't want to go through any further decline, and others who might want to wait until the nth moment and try to eke out as much as they possibly can. For patients who are on track one, which again many people with dementia would be, they could fill out a waiver of final consent. So in most cases with MAID, the patient has to be able to look you in the eye at the time of MAID and confirm that they're consenting to receive medications that would end their lives. But with the waiver of final consent, which was introduced in 2021, and that's for people who are on track one, if they're prepared to set a date for their MAID provision and there's some risk that they would lose capacity prior to that date, they can sign the waiver with their MAID provider. And people with dementia can do that. So with somebody who has capacity, still even with an early to moderate dementia, the capacity to make the decision to receive MAID, not necessarily, they may have lost capacity for other things, but if they retain the capacity to consent to MAID and they have the capacity to execute a waiver of final consent, which is sometimes problematic, but if they have that capacity, then they can do that. And then if they lose capacity, then it's possible for them to receive MAID. Now, individual circumstances, it's much more complicated than I've just talked about. I think it's complicated to provide MAID using a waiver of final consent for somebody who has a dementia for a variety of reasons that I think we won't go into the weeds on that one, but just to say that it is possible.
Okay.
But the waiver of final consent, it is time limited. It's not an open-ended date. There cannot it cannot serve as an advanced directive.
Exactly. So they have to have set a date for MAID.
Yeah. Okay. Thanks so much, audience member. Next question, and we'll pose this towards Chantal. This person asks, since patients are not necessarily required to to undergo any recommended treatments, how does that impact your decision as a clinician to approve or reject someone who's track 2 if they're trying to refuse treatments that might otherwise help them or alleviate their suffering?
I fall back on it's a case by case decision, and the nuances are in the details that would come out for me in the course of doing an assessment. People have a right to refuse treatments, even treatments that I or somebody else might think would be reasonable treatments for them to try. If someone has said, I've been through all of this, I've tried a whole bunch of things, I just don't want to try anymore, even if there's something that I think, well, this could alleviate this particular symptom or this part of the condition. If they're able to say to me, but that still would not let me do A, B, or C, or that would not give me the quality of life X, Y, Z that I want, that would be meaningful to me in my life, then it's possible for them still to be eligible for MAID without accepting any of the treatments that are currently being offered. Now, if someone was just diagnosed with something, or even if somebody had lived with with condition for a period of time, but they had never tried any treatment at all, I would have difficulty with that. And that's somebody that I may not find eligible for MAID. And I would likely work with them and try to talk to them and support them and encourage them to at least try some treatments. But again, it's hard to speak about this in this kind of context because you don't have the nuances and details of the assessments or the particular conditions.
All right, thank you. Eric, this next question is for you. This audience member asks about what to do if my doctor won't even discuss my wishes with me, if that includes MAID. Where could they go in terms of a next step?
First and foremost, the doctor is not just ethically obligated to forward the decision. They're pretty much they're legislated by and large to forward the request. In Ontario, the minimum effective referral is to hand them the phone number for a MAID coordination services. Now, if you were to just do a Google search and look up, MAID coordination services, you'd probably find it. But it is important that the physician do pass on the referral. And we do know that there's physicians who are anti-MAID, but they're obligated by their college to do effective referral. So you could say, refer me, or I'm going to report you to the college, pretty heavy-handed. But there's obligation to make referral, effective
Okay.
referral.
Thank you. And we have more information about effective referrals in a webinar on our website as well. And you're more than welcome to take a look at that to learn more.
Well,
Okay.
the best thing would be to call Dying with Dignity. That'd be the best thing to do.
Always.
Yes, or to speak with your healthcare team. Okay, we've got just a few more minutes here for interview or for, excuse me, Q&A questions. So let's go back to Chantal. This question is related to MAID and mental illness, and we did talk about the fact that there's a current sunset clause that's set to expire for March 17th of 2027, after which individuals whose sole reason for applying for MAID is a mental illness. But this audience member is curious about why mental illnesses are not presently included under Track 2 MAID. I think they're a bit confused there about the domain of mental illnesses and how it relates to things like neurocognitive disorders, or not having a reasonably foreseeable natural death, which Track 2 represents.
I think, well, to answer that question, you really have to speak to the legislators because they put the exclusion and with the sunset clause in the legislation in 2021. I think when the original legislation came in with Bill C-14, there was a mandatory review of MAID and specifically to focus on people with mental disorders, mature minors, and advance requests. And those things that were specifically excluded from the initial legislation, I think with the view to at some point in the future that they would be included. And then as a result of the changes that happened in Bill C7, there was again the mental health people with mental disorders as their primary diagnosis were excluded, but with the sunset clause of 1 year, and then that was extended and extended again to 2027. So it's the legislators who decided to do that. And I think they got a lot of pushback from some psychiatrists and clinicians who disagree with it. And so from some of the general public, particularly people who are against MAID or seeing people with mental disorders as being too vulnerable to be able to make their own decisions. And again, somebody with a mental disorder as their sole underlying condition, in order to receive MAID, they have to have the mental capacity to make that decision. So if they're in a psychotic episode or if they're so depressed that they're not thinking straight or whatever the situation is, if they're not able to have capacity to consent to MAID, they're not going to be eligible. Does that
Okay.
answer your question?
Yes, thank you so much. And thanks, audience member. We've got time for just one more here. And I'll present this to both of you. And Eric, if you'd like to start. This audience member asks, what would you say to those who say that Canada has too many individuals dying by MAID, or that MAID is becoming the most common reason or a quickly rising cause of death for individuals across the country? Eric, what would you say to that? And then followed by Chantal.
MAID is all about choice. And as time has gone on, more and more Canadians know about MAID. They understand it, not just through organizations like Dying with Dignity, but I'm finding that when I interview somebody new, they know of someone who's been through it. So there's more intelligence, more knowledge about what MAID is, and that's really the driver as to what's causing still increasing referrals. So to me, it's a meaningless statement to say, well, too many people are dying from MAID. They've made that choice, and this is particularly for well, I mean, most for track one. They know what their options are, and if they opt to choose MAID, knowing that hospital care, knowing that palliative care, knowing that hospice care, etc., is available to them. If MAID is their choice, and that is their choice, and that's what makes this a great piece of legislation for this particular country.
Absolutely. Chantal, any remarks from you about that? What would you say?
Yeah, think sometimes comments like that are trying to suggest that somehow MAID is increasing the number of deaths. MAID does not increase the number of deaths. MAID is simply a form of dying, and it's relieves suffering. It gives people a peace of mind. I think it's a very um, peaceful and beautiful way to die, which I've certainly seen with patients, and the patients agree with that, and the families agree with that. So the fact that the percentage of deaths, of overall deaths, is rising due to MAID, I see that as a good thing because people are exercising, as Eric said, their autonomy and their choice. They're making that decision to end their suffering and cut off a certain amount of suffering that they would otherwise have to endure. And I don't understand why people would think that that is a bad thing. I would expect as MAID becomes even more known than it already is, and people have more experience and recognize that it's not people being pushed into receiving MAID, it's people asking and in many cases begging to receive MAID, that people will relax a bit more about that and see that it actually is a good thing. And I expect the percentage of deaths actually that are due to MAID will actually rise. And I don't see that as a bad thing either.
All
But
right.
the detractors will not be altering their position, and we just know that.
And these remarks will be taken out of context and misused, I'm sure.
Oh,
Oh dear.
definitely, definitely.
All right. Well, Chantal, Eric, thank you both so much for your time today, your presentation, your insights, your expertise. We're a thrill and a joy to listen to throughout the session. I also want to thank all of our audience members for your registration questions throughout the session, and for your attention. And we hope that you find this webinar worthwhile. It's thanks to the generosity of our supporters, just like you, that we can provide webinars like this, as well as all of our other compassionate services, 100% free of charge to people across Canada. And so, in that spirit, we ask that you please consider paying it forward and empowering us to continue the work that we do by making a donation today. Thank you so much for your support. Thanks for your attention today. And as a reminder, the session will be recorded and uploaded to the website, so keep your eyes peeled for that email. Chantal, Eric, thank you so much again.
Thank you.
Hey, thank you, Amanda.
All right. Thanks again, everyone, and have a pleasant afternoon. Bye-bye.